Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. Good morning and welcome to the Appeals Court. I am Justice Rubin, and I'm very pleased, and you should be very pleased, that I'm joined today by two outstanding colleagues, Justice Sachs and Justice Ditkoff. We are holding oral argument, of course, by teleconference due to the ongoing pandemic. And the rules for argument at when we do it by video conference like this are the same as they are in the courtroom, which is to say 15 minutes per side with no rebuttal. The first case we will hear today is number 20-154, Commonwealth versus Senku Us. I may be mispronouncing that name. I have little doubt that I am. And we will hear first from you, Attorney Oresti.
Thank you, Your Honor. Good morning, Your Honors. May it please the court. I'm Attorney Rod Oresti for the defendant, Froylan Senkuis. The issue in this case is whether Mr. Senkuis's performance on the field sobriety tests during the stop, as well as his post-arrest statements, should have been allowed into evidence or considered when a clear language barrier existed between him and the state trooper. Now, there was a motion in limine to exclude the field sobriety tests made by defense counsel before the trial, which the trial judge stated he would hear evidence regarding Mr. Senkuis's ability to understand English. From essentially the beginning of the officer's testimony, however, it was clear that Mr. Senkuis, English was not his primary language, Your Honor, and he could understand very little. The only time the officer and Mr. Senkuis actually were able to communicate was when the officer spoke the little Spanish that he knew. Still, during the trial testimony that Mr. Senkuis performed and failed the 9-step walk and turn test entered, even though the officer testified that he administered the instructions in English. And I point to the Commonwealth versus Lujan case, where in that case as well, the issue was whether or not the defendant understood the instructions of the field sobriety test.
But the judge said at the close of the evidence, I think, that he gave very little weight to the field sobriety test. So what prejudice would there be from any failure to
he did
include it?
Sorry, Your Honor. He did say that he gave very little weight. What I am putting forth is there should have been no weight to the field sobriety test, Your Honor. They shouldn't have even been included in the evidence because it was clear there was no understanding of the instructions between the police officer and Mr. Senkuis. Similarly, no statements after the arrest should have been allowed or considered because of the language barrier as well. The officer testified upon arresting Mr. Senkuis. He recited the Miranda rights in English. Again, it was clear Mr. Senkuis didn't understand English. The Commonwealth versus Sen case states that Miranda requires a defendant should be given his rights in a language he understands, which didn't happen in this case either.
Why does that matter without interrogation?
Well, it matters, Your Honor, for the statements that he made while he was in the car. He didn't understand English. He didn't understand his rights. However, what the court took as evidence were his statements that he was calling the officer names.
But without custodial interrogation, why does it matter whether Miranda was given?
He didn't understand his right to remain silent, Your Honor.
Okay, but if he, again, without custodial interrogation, why does it matter? I mean, Miranda, you have to give that before custodial interrogation. Without that, why does it matter? He certainly didn't understand his Miranda rights.
Yes, correct, Your Honor. And Also, the issue is, whether or not his statements were voluntary or not. That's the bigger issue, Your Honor. And if his statements were voluntary or were involuntary, then they should not have been allowed or
What
considered.
reason are you suggesting that they weren't voluntary? I don't hear you arguing that he was too intoxicated to make an intelligent decision about whether to call the trooper names.
Correct, Your Honor, but he didn't. So under Souza and Selby, Your Honor, the totality of the circumstances test of whether a statement is voluntary or not takes into account whether or not a person understands why he's being arrested or what is being communicated to him. I put forth to you that Mr. Sanquez didn't know why he was arrested. He didn't know why he was in the back of the police car. He made these statements, and the judge or the judge concluded that those statements were evidence of belligerence due to his use of alcohol. I argue that a rational fact finder, given that Mr. Sanquez could not understand what was happening or what was being communicated to him, he made those statements for a reason non-alcohol related. He was panicking, and that's those FSTs. There was insufficient evidence to find belligerence, and insufficient evidence ultimately to find that he had a diminished capacity to operate a vehicle due to alcohol. With that, Your Honor, that's all I have. So I will rest on my brief and unless there are any other questions.
See none. Thank you very much. We will hear next from Attorney O'Neill.
Good morning, Your Honors, and my brother, Mary O'Neill for the Commonwealth. My brother's appellate argument has problems in a number of ways, not the least of which is procedurally. First off, he's really not entitled to the relief he's asking for, and that is because if you look at the online docket, his defendant is on default as of October 7th of 2020, a fact that came to the Commonwealth's attention late yesterday. So the Harris case says the court can, of course, continue to indulge the appeal, but he's not entitled to it. But there's another reason procedurally why he has a problem. That is, he's asking for the wrong relief. He wants a not guilty. The defendant requested not guilty based on an insufficiency argument based on inadmissible evidence, but he wouldn't get a not guilty. He would get a new trial. So there's a problem there as well. The bigger problem comes about where at trial counsel, who did a fine job, defense counsel, he didn't object. So the standard of review here, obviously, is substantial risk of a miscarriage of justice. And what I would frame the facts, some of the facts that I will give to the court, but unless the court.
Are you suggesting he didn't object to the field sobriety test coming in?
He did a motion in limine. And when the motion in limine was completed, the judge, as the court knows, the judge said, well, let me hear from the officer and then I'll decide. There doesn't seem to have been a denial of the motion in limine from what I can see from the papers. And there's a point, I want to say around page 30 something, I'll check it again, but where he offers to defense counsel, do you want to argue the motions? And he says plural. So that's one motion clearly is the motion for the required finding. It would be a fair assumption that the other motion is the motion in limine. But in any event, and this is what struck me from the transcript, the judge on page 81 of the transcript, and he alludes to it earlier as well, he wants to be careful so that nothing, or to quote him, he wants to be careful about what's not lost in translation. So that's in his mind from the get-go. The motion in limine has told him we've got a language problem. He's aware of that right from the beginning and continues that way throughout the trial. And that's why, as he states, the judge, I don't give much weight to the 9-step heel step test, because something could be lost in translation there. And that seems to be the gravamen of my brother's argument. So you've got a judge who's being very careful, a judge who did not deny the motion in limine, and a judge who has stated on the record more than once, I want to be careful about what's not lost in translation. Now, having said that, you then, and I confess I'm confused. I felt like I was going on a snipe hunt to find the statements that were wrongly admitted. And almost all of what was admitted to support the Commonwealth's argument of operating under the influence and operating negligently were not statements, but actions. The only statements that came in were statements in Spanish, and those that my brother cannot argue Spanish statements when he says that's his native language and that's what he understands. So that really can't be the basis of any argument. And then what other statements come in? The spontaneous exclamations of help, and not much else. And spontaneous exclamations are not excluded under this theory. So having said that, we look to what actually was the bulk of the evidence, and the bulk of the evidence was the observations of the driving, both by the EMT for 10 miles and then by the trooper, the observations of how he stopped that the trooper saw, the observations of him getting his registration fine, but not his license, getting out of the car okay, but then stumbling to the front of the car. Yes, there was testimony about the field sobriety test, but as I've already pointed out, judge didn't give it much weight. He wanted to be fair. So then you have further evidence of him falling asleep in the car after swearing and yelling, help, help, and then needing some assistance, and scraping a guardrail and needing some assistance to get into the booking room. And as the judge pointed out, because he looked at the 45-minute tape, wasn't anything dramatic there, but clearly he had some trouble walking and he used the counter to hold himself up. So the judge did fine. Lattimore was met. And given that, and given the wrong basis for relief here, I would suggest to the court that the Commonwealth should prevail here. But I'm open, obviously, to any questions from the court, because honestly, I'm scratching my head. I'm not sure exactly what got in that tilted the scales to error or substantial risk of a miscarriage of justice. No? Well, if there are no further questions, I'm going to rest on my brief, but open to any questions.
All right. Seeing none, thank you very much both. Helpful arguments for us. The case is submitted.
Thank you, Your Honor.
All right, we are live and recording.
Thank you. Good morning. Welcome to the Appeals Court. I am Judge Rubin. I am joined today by two excellent colleagues, Judge Sachs and Judge Ditkoff. The next case we will hear is number 20-852, Commonwealth versus Cortez. We are, of course, holding this argument by teleconference due to the ongoing pandemic, but the rules for argument are the same as they are in our courtroom. It's 15 minutes per side and there is no rebuttal. And we will hear first from you, Attorney Power.
Thank you, Your Honor, and good morning. Andrew Power for Defendant Israel Cortez. I'd like to begin with three facts, if I may. First, the government destroyed all of the drug evidence in this case prior to arraignment, without notice, without a hearing, and without a court order. And counsel didn't know this until the day of the plea. Second, at the time of the plea, the drug lab was closed, the drug analysts were suspended, and the whole operation was under investigation. But counsel didn't investigate its impact on this case. And third, the Middlesex DA has argued to the SJC just recently that a cloud of doubt still hangs over all testing performed at the drug lab, including that of Della Saunders, the principal analyst in this case. And that should be the Commonwealth's position here as well. Now, on December 3rd, 2012, a hearing was scheduled on the defendant's
May
motion.
I ask, I think we've probably got the basic outline of the facts. I wanted to go right to your point that the destruction of the drugs was done in bad faith or recklessly. We don't know who destroyed the drugs. About all we know about that issue is that the lab back in 2005, I think, or 2006, had a rubber stamp that said destroyed. In the absence of evidence that any of the analysts themselves were involved in the destruction, Saunders and the two others, what basis do you have for attributing the destruction to the what we might call the prosecution team? I understand that where an analyst has been directly involved in some misconduct involving the evidence, then that can be attributed to the prosecution, but I don't see that here.
Okay, I will attribute it to the prosecution team under three provisions, I guess, two constitutional provisions, one statutory and one rules provision, all of which impose on the Commonwealth a duty to preserve this evidence for trial. Now,
well, going to the rules provision, which I assume is the mandatory discovery provision, if the violation of that rule were grounds for excluding if the violation of that rule were grounds for the relief that you're seeking here, then why would we need special rules like were recited in Williams about the destruction that's in bad faith or reckless, or that the defendant has to show a reasonable possibility that access to the lost or destroyed evidence would have produced evidence favorable to his cause?
Okay, well, first, I'm not arguing bad faith, I'm arguing recklessness, just to be clear. But I think this violation of mandatory discovery puts us in the case law of Glinowitz, where there was an order not to destroy the evidence, and it was destroyed, or in order to preserve the evidence. And there is case law that says, I believe it's Cotto, that says Rule 14A1A7 acts as that type of order, but it's put in a rule instead of an order. So it's always in effect that the Commonwealth is required to preserve that evidence for the defendant if he chooses to inspect and test, because it's in a drug case, in a drug trafficking case, obviously there's no question that the drug evidence would be a relevant, tangible object under that rule. But I also want to discuss the three other provisions, which are equally, if not more important, especially Chapter 94C, Section 47A, which I submitted belatedly in a 16L letter. But that provision forbids the destruction of drug evidence in an open case without judicial process. So there has to be notice, there has to be a hearing, and there has to be a court order before the Commonwealth can destroy the drug evidence.
So this wasn't argued below. Why should we, for the first time on appeal, decide whether the violation of that statute, if it was a violation at the time, since the Cotto decision didn't come out until 10 years later or so, whether the violation of that statute entitles the defendant to any relief in these circumstances where, if the Commonwealth had attempted to give notice, the defendant was whereabouts unknown for a period of about 9 years, and this fell right in the middle of it. In addition, that statute says the drugs can't be destroyed unless there's some test done and a notarized certificate prepared of the test results. We have that here.
But
So
Cotto
why should
says
we decide that alleged or claimed violation entitles the defendant to relief?
Well, Cotto says that it forbids destruction of the drug evidence in all cases. And you can see from the statute, first of all, the statute was in effect, and the copy I sent you was the 2005 statute.
So we can concede it meant the same thing all along.
So it meant the same thing all along. And the point of the statute is to preserve samples for the defendant to have access to. So that's the point of having the notice, the hearing, and the court order. Now, none of that happened in this case. Now, I'm saying that you add that to the calculus. In addition to the violation of Rule 14, we have a violation of Section 47A. Now, we also have a violation of the constitutional right to access the evidence for independent testing. And that's something I certainly argued below, as well as the Brady violation, because destroying the evidence has the same effect as withholding it. So we have two constitutional violations, Brady and the right of access, one statutory violation, 94C Section 47A, and then the mandatory discovery violation under Rule 14. So I think if you add these all together, I think suppression of the test results under the Glinowitz standard and or dismissal of the indictment under the Sassville standard would certainly have been proper sanctions for the Commonwealth's reckless conduct in this case.
Counsel, doesn't that position require us to overturn Williams, which tells us exactly what to do when there's destroyed evidence?
I don't believe so. And the reason I would say that is because I would cite to Williams at page 718. Now, Williams says, where the Commonwealth has acted in bad faith or recklessly, resulting in the loss or destruction of evidence, the defendant may be independently entitled to a remedy even without meeting this test. So Williams carves out an exception for exactly the situation that we're in here.
Well, if it were reckless, but why is the remedy suppression rather than an instruction?
Well, the remedy is suppression under Glinowitz because, as the SJC found, it's unfair for the Commonwealth to make use of test results when the defendant was unable to conduct an independent test of the same evidence. So in Glinowitz, the SJC held that suppression of the test results should have been granted. And Glinowitz is a very similar case to this one. You know, in Glinowitz, the Commonwealth allowed the destruction of evidence during forensic testing. So comparable
in Glinowitz,
testing,
that was an expert acting on express instructions of an assistant DA. I'd like to get back to the question of where we have no idea about the circumstances of the destruction here and whether anyone who was in any way in touch with the prosecution was involved in the destruction. How can we say that the Commonwealth or the prosecution team acted recklessly? What's your best case for that?
My best case for that is would be either Glinowitz or Sassville. Those are my best cases on this subject.
Well, it is the Commonwealth one way or another. I don't really, I mean, the Commonwealth is, there's state action here and it's the Commonwealth who destroyed this. And I don't know there's a difference between a team and this is the lab used by the police for testing and so on. So I'm willing to say, I don't know if my colleagues are, I'm willing to say the conduct is chargeable to the Commonwealth. But you're saying it's reckless as a matter of law rather than merely negligent or grossly negligent or stupid or even explicable because we don't know the facts and circumstances exactly. Did you seek more information about what happened, about whether it was a routine practice, about whether there was a misunderstanding, about the case being closed? And can you also tell us that there was a long gap between the testing of the drugs and the trial or the hearing at which this was revealed, the motion to suppress hearing? Was the defendant a fugitive? What happened? Do you know?
My understanding from the record is that the client was deported and subsequently returned to the United States and was apprehended at that time and brought in. That's only from the record. I don't have private knowledge of what.
No, I don't want private knowledge.
Mm-hmm. But I also want to point out that even going under the Williams reasonable possibility standard, we can still show that the testing at the drug lab could have been unreliable so that this evidence would have shown that the testing was possibly invalid. I mean, relying on the OIG report, there's plenty of references to sampling issues and the unreliability.
But
I mean,
So that report,
showed I'm sorry.
Oh,
You
go
can
ahead.
show that regardless of whether the drugs were destroyed. So I don't see what the problem is that you can show all the bad stuff about the testing without having to touch the drugs. You've got all that. It's in your appendix. But why is that something that fits in the Williams test?
Because that meets the reasonable possibility standard. The Williams test is to show a reasonable possibility that the testing could have been invalid or there could have been problems with the testing. So we are showing now, based on the OIG report, which plea counsel didn't investigate. He didn't have access to it at that time.
The Williams test, don't you just show as a reasonable possibility that if you had the drugs, they would be exculpatory?
Yes, so there would be exculpatory evidence regarding the testing. Now, this was drug trafficking, so that could go.
That's not my question.
Mhm.
Maybe your answer is no, but my question is, under the Williams test, don't you have to show that if the drugs still existed, there's a reasonable possibility that the drugs themselves would be exculpatory?
No, I believe the test is that the drugs themselves would produce exculpatory evidence. The drug evidence, we don't know that they're drugs. The powder would produce exculpatory evidence. Now that could go to the weighing of the powder, flaws in testing the identity of the powder. There are a lot of different things. The use of statistics as they were applied to this powder and the methodology used to test this powder. So it's really, there are a lot of different things that could be exculpatory in regard to the powder that was destroyed by the government in 2005. And the Commonwealth does not disagree with us.
And for the reasonable possibility, you rely on the OIG report.
On the OIG report, as well as the subsequent analysis that was brought out in my first motion for judicial notice, showing that one of the chemists in this case, Della Saunders, regularly had productivity numbers far exceeding those of her colleagues and nearing those of Annie Dukin. So at this point, it's an open question, as the SJC single justice has acknowledged, that there may be problems with Della Saunders' work at the drug lab. You know, was she dry labbing? Was Annie Dukin the only one?
Did you raise this below?
No, this didn't.
You can always bring a new motion, right, to raise that issue, right? But that's not exactly before us, is it?
Well, again, this is more evidence.
Okay, but we don't take evidence.
Flaws in the testing process. And I'm not using that as evidence. I'm simply using that to show that it's an open question right now, and it's an ongoing open question that the Middlesex District Attorney's Office has acknowledged. I mean, the Commonwealth's 211-3 petition last month questioned whether any testing performed at the lab was reliable. You know, District Attorney Ryan cited unanswered questions about the significance of Della Saunders' high testing numbers, and that was acknowledged. I mean, this just happened a month ago. So yes, I'm asking the court to take judicial notice, not of the underlying evidence, but simply of the fact that this is being argued throughout the justice system, and these results are being questioned not only in this case, but in other cases as well. And so given this showing, I think we've established at least a reasonable possibility that there were flaws in the testing process that could have been exposed by counsel's inspection and retesting of the powder had it been accessible or had it not been destroyed. No further questions.
Just turning to your motion for post-conviction discovery, it's very difficult to know what to do with that when the motion is not in the record appendix.
The judge's ruling is in the record appendix, and the motion is attached to the reply brief. It's in the addendum to the reply brief, so you can access it there.
Okay, thank you very much. Your time has expired. If there are no further questions, we will hear from you, Attorney Blatchford.
Thank you, Your Honor. May it please the court, Assistant District Attorney Howard Blatchford on behalf of Middlesex County in the Commonwealth. Your Honor, let me begin by addressing the last issue that was discussed first, and that is the question of the petition filed under Chapter 231, Section 3, 211, Section 3. The The thrust of that petition was to inquire, and it's stated on page 4 at the bottom of the petition, the question presented for the single justice was whether the district attorney could continue to rely upon the OIG's investigation and the report that was issued in 2014. In particular, in connection with the activities of Sonia Farrick, who worked at the Hinton Lab in 2003 and 2004 before she moved on to Amherst. That was the thrust of the petition. And it's important to recognize that the drugs in this case were tested in 2001, between April and June of 2001, which was 2.5 years before Andy Dukan began work at the Hinton Lab in November of 2003. And that date is established in the Bridgman case, as well as in the OIG report. Furthermore, these drugs were tested by the lab a year and a half before Andy Dukan, a year and a few months before Sonia Farrick began there in May of 2003, about 1 year. Neither of those chemists tested these drugs. Their signatures appear nowhere on the documents. So this case of Israel Cortez really is outside the scope of the OIG report. It happened a year before that investigation. It happened a year before that the scope of the investigation began in 2002 and ended in 2012. So we don't believe there's any inconsistency whatsoever between the Commonwealth's position in this case and the fact of the filing of the 211-3 petition last month, and the fact that the drugs in this case were not tested by either Dukan or Farrick. So moving on to the arguments raised in the brief on appeal, first of all, we argue that the defendant did not demonstrate a reasonable possibility based on concrete evidence that the drugs that were seized and tested were not heroin, cocaine, or procaine. The mere fact that they were tested at the Hinton Lab is insufficient to raise that possibility. And the defendant relies largely on innuendo in an attempt to taint the testing, saying that one of the chemists held the same title as Andy Dukan did. Another worked in the office next door to hers, and so on and so forth. There's no concrete evidence whatsoever that there was any improprieties with respect to the testing of these particular drugs. Furthermore, the Commonwealth could have proven its case even without the drugs. We had the certificates. The chemists were available to be summoned in if necessary. There's a document from the Mass State Police Human Resources Department. It's in the record appendix indicating that the analysts were to remain available throughout this period of time and to be reached by telephone. And furthermore, there was evidence that at least one of the chemists here, Della Saunders, was testifying in court.
Counselor, do you know when the leave ended?
Excuse me?
Do you know when the leave ended, when they were unsuspended?
I don't know that date, Your Honor, no.
Is there a requirement in Melendez-Diaz or elsewhere that testifying analysts who did the original testing have access to any particular underlying notes when they testify? Or can they testify and be effectively cross-examined based on their certificates and their knowledge of what testing procedures were?
Yeah, I believe it's the latter, Your Honor, that there's no absolute requirement that they have the documents there with them. Obviously, when a chemist such as this or any expert testifies, they typically do have them available to refresh their memory or recollection. And there's no suggestion here that the documents themselves could not have been summoned if necessary, and these chemists had to come in to testify at a trial.
Can I ask a question? Ultimately, the test in one of the cases, I don't remember which one, once a threshold has been passed, is something like fundamental unfairness or something like that. And I don't think it's a matter of federal due process. I think there's actually some case law about that. But I'm just trying to figure out, the Commonwealth takes the evidence, seizes some evidence. They send it to a lab. I don't want to use the word in secret, but it's not, it's like private. They don't send it to a neutral lab. There's no chemist for the defendant present when it's tested. It's done by the government in a government building for purposes of determining what the drugs are for use in a criminal prosecution or investigation at least. The government tests the drugs, the evidence against the defendant, and then destroys them. And then comes into court and says, doesn't matter that they were destroyed. I have this document here where my employee says they looked at it and it's cocaine or whatever, heroin and cocaine in this case. And I understand that, you know, maybe I don't know if it's judicial notice. We think usually the tests are right, although no one was there except government employees when they were done. And now the drugs are gone because the government got rid of them. And I'm just trying to figure out the fairness of saying, and now we're putting you, defendant, on trial. I know we don't have the evidence against you, the raw evidence seized from you. You can't hold it up to the jurors and say, this is sugar or whatever. We destroyed that. But our people looked at it first, yours didn't, and they concluded that it's cocaine. And that's how we're going to put you in jail. Isn't there a fundamental fairness problem there?
I don't think so, Your Honor, as long as the testifying chemists are subject to cross-examination.
But the evidence is gone. Sure, of course, they can be subject to cross-examination all they like. They think they did a great job. They're going to say that. We always do a great job. We think we did a great job. But they threw away the evidence without, it's not there. I'm just having a hard time with, do you have a Massachusetts case where someone was convicted on the basis of certificates after the destruction by the Commonwealth of the drugs against them? Is there a case like that?
I'm not aware that we found anything holding to that effect, Your Honor. But again, I would say there's no evidence as to recklessness or bad faith here. They just got destroyed.
It might be reckless to destroy. I mean, again, I don't know why it was destroyed, and the record doesn't seem to show why it was destroyed. I'm not sure where the burden lay on that in the trial court. It's arguably reckless to destroy the drugs before the prosecution is complete, right? I mean, it's certainly a bad mistake.
It certainly was unfortunate, and the reasons for that having happened, we don't know. Again, I would say that it's not only is cross-examination on this appropriate, but argument by defense counsel and possibly instruction by the judge. I think the case law in Massachusetts suggests that in the absence of bad faith or recklessness, that's an appropriate sanction.
But just like all of us sitting here have a kind of sense, well, I don't know about Attorney Power, but have a kind of sense, these certificates are probably right. They tested the drugs, right? So, yeah, I guess it could be wrong, but 99.8% probably right. I mean, if you introduce those certificates, you're gonna get a conviction. And it's gonna be very hard. And I'm not saying if they had the drugs, maybe they wouldn't test them because they know what they're gonna show, or maybe they would test them and they would show exactly what your certificates say, but they don't have the drugs. And there's something odd about that. I'd be a lot more comfortable if this had happened before and some court had said, yeah, you can go ahead with just the certificates and you can let them in. I'm just not sure. There's an argument to be made that it's unfair to even let the certificates in. Maybe it's a 403 argument. The risk of unfair prejudice, if it's wrong, is very, very high. And yet, I mean, then the probative value, these are the certificates are overwhelming evidence in a way of the contents of the drugs. I don't know if you have a response to that. It's not really a question.
I understand the concern, Your Honor, and I think that, again, I would go back to the issues of cross-examination, argument, possibly instruction as a way to cure that, or at least ameliorate the situation.
What instruction would you be able to give, though? Ladies and gentlemen of the jury, the Commonwealth has destroyed the evidence, and we don't know why. They bring this certificate in, but what? You may infer from their destruction of the evidence that if the defendant had it, it would be favorable to him?
Like a De John Batista instruction or something?
I mean, that's a pretty, that seems almost too strong.
Well, maybe
it would be too strong, I believe, in the absence of bad faith.
If there were bad faith, you would do that. Of course, you'd say, well, bad faith, why'd they do it? They did it to hide.
The issue before us is an ineffective assistance issue. So the question is, was Attorney Valerio, was his performance deficient in failing to explore some of these remedies, and did his failure to explore them deprive the defendant of a substantial ground of defense?
I don't think they did, Your Honor, for the reasons stated in our brief, that the defendant had the initial burden of coming forward with concrete evidence that the drugs would prove to be exculpatory, and they rely instead upon innuendo about other people who worked at the lab, and offered nothing concrete to suggest that.
Right. But my point is, why couldn't the defendant argue, well, the Attorney Valerio's failure to consider that he could go to trial and make an argument that the government destroyed this, and why would they destroy it if unless they knew that the defendant's access to it would turn up evidence that it wasn't cocaine or heroin, or wasn't the quantities measured. So the jury should draw an inference that the certificates were wrong. Why wasn't it ineffective for the defendant to, for defense counsel not to have done that?
So I guess I have to go back to the testimony that we had at the evidentiary hearing on the motion to withdraw the guilty plea. As you know from Judge Hopkins' decision, these were very serious charges against Mr. Cortez. If he had been found guilty on all of them, including the trafficking charges, and he's received the maximum sentence.
Although the Commonwealth admitted at sidebar there were some weaknesses in its case. This was a joint venture case. The case against the co-defendant had been much stronger.
It did. Unquestionably, that was recited to the judge at the sidebar. But the point here, I think, is that notwithstanding the severity of the charges and the severity of the sentences that could have been imposed, when confronted with this, and this was the testimony of defense counsel at the hearing, he explained to his client, Mr. Cortez, the options that he had. He could go forward with a motion to suppress. They could have litigated the case. He now had knowledge that the drugs were destroyed. He could have perhaps done something with that fact. And he explained to Mr. Cortez, you got that option, or you have the option of simply taking what's being offered now. And that was a 1-year House of Correction sentence deemed served.
May I ask about the time served? By essentially wrapping up his sentence that day, did he then start getting credit towards other sentences that might be imposed in the future? In other words, was he held on other charges?
He was held on other charges. There was an immigration detainer on him also at that time. But he said that the client was very clear that he did not want to prolong it any longer. He wanted to end it and end it on that day. And that's what the judge found. She credited defense counsel's testimony over contrary allegations contained in the defendant's affidavit in support of the motion.
Okay, your time has expired. If there are no other questions, Excellent arguments from both of you. Very interesting case. It is submitted. Thank you.
Thank you.
And we hear argument by teleconference, as we're doing today in light of the ongoing pandemic, are the same as during live argument in the court, which is to say 15 minutes per side with no rebuttal. And we will hear first from you, Attorney Magicomo.
Thank you. Please the court, Joseph Magicomo on behalf of Valerie Semense. If you could just indulge me for 5, 4, 3, 2, 1. That is the context in which this unfortunate act.
I'm sorry, we're having a little technical difficulty here, Attorney Magicomo. We're having a little technical difficulty. You're frozen. I'm sorry. Can we pause? I don't see that we're live. Yes. All right.
You're now live and recording.
Let's try this again. Counsel.
Thank you, Justice. Those 5 seconds are the framework for the context of this accident. With reference to Ms. Semense, I would suggest to the court that the analysis must of an unreasonable risk of physical harm to another actor that could have been prevented. Basically, the Commonwealth has to prove that Ms. Semense failed to exercise ordinary care within those 5 seconds. And I say within those 5 seconds because the evidence suggests that as Ms. Semense was backing into the parking space at the Brockton District Court, she was tapping her brakes and going slowly. It was not until the vehicle jumped the curb for whatever reason, whether it be pedal misapplication or whether it be spontaneous acceleration, that then the analysis starts with reference to Ms. Semense's actions.
Can I ask you, how can, I take it from what you've said that you agree there was sufficient evidence for the jury to find pedal misapplication. How can pedal misapplication be anything but negligent?
Well, I would be remiss to agree that it was pedal.
Okay, you're okay. I'm sorry. Let's stop for a second.
Application. I think it is an open question,
counsel,
although trial counsel did it.
Counsel. Very good.
All right, you're live and recording.
All right, counsel. I had asked you about pedal misapplication, and I had said that if the evidence were sufficient to support that, not that you would concede pedal misapplication, but if the jury could have found that, can pedal misapplication be anything but negligent? And now over to you.
Thank you. Well, first off, again, I don't concede that. I think trial counsel did a deplorable job in this case, if you read the record on appeal. That being said, whether it is, if in fact the jury were able to find pedal misapplication, I would suggest to you that it still would not rise to the level that the Commonwealth would need to support the issue. The reason being is that there are numerous studies out there, which I reference with reference to the neurological issues that come along with pedal misapplication. And not only that, I would suggest to the court that without more, pedal misapplication is nothing more than making a mistake, which would be an accident. For the Commonwealth to succeed in the case, they would have to show that within that 5 seconds, that a reasonable person would not be able to counter the issue of a pedal misapplication. And I would suggest to the court that anybody who watches NASCAR, let's take for example, would say when something happens and you're in a panic mode, even professionals have a hard time countering within a 5-second time window. If the Commonwealth were able to point to 15, 20, 30 seconds, there may be a justifiable argument. But the evidence suggests that Ms. Semensi was in a panic. The evidence suggests that she was screaming for help, as any of us that know Brockton, the district court parking lot. The Mercedes jumped the curb, went up the grass, went over a driveway, jumped some more grass trees before striking the individual.
But surely you agree that doesn't happen all the time. Right?
Well,
People are not routinely, drivers who are taking due care. We don't have this well-known phenomenon, pedal misapplication for 5 seconds, right? I mean, we'd have wrecks everywhere, and we don't.
Well, I would suggest to the court that, first off, the North Carolina study that I cited does show that it is predominant within elderly people. Ms. Semensi was elderly.
Okay, but now let me ask you this. Is that the test? Let's say there's something elderly people can't do well. That, let's say when they're doing their very best, they just can't do it as well as younger people. I mean, this seems to me like sort of the lurking question here.
It does, Justice, but we have the AARP, which is a strong lobbyist. She does have a license. Her license is reissued every time it comes up. And we as a society have accepted the fact that as people get older, Ms. Semensi is shorter in stature, things that are listed within those studies, that is acceptable. And I would suggest to the court that being that society accepts that as acceptable, then the Commonwealth has to point to something else.
But so let me ask you this, because it's interesting.
I mean, did she create?
Maybe it's more interesting from an academic standpoint. Of course, deciding what counts as negligence and deciding what counts as due care, all of that does involve calculations of risks and benefits and what's tolerable and what's not. And we let people have baseball games where foul balls hit people, and we let people have ski resorts where people could be injured, and so on. And judgments are made by legislatures or sometimes by courts at common law about what's okay and not. But are you suggesting that we should be using a reasonable elderly person standard or a reasonable person standard?
I would suggest to the court that in light of the fact that the predominant number of pedal misapplications are within a certain age group, and in fact within the female gender, that the court may someday move to that point. We are not at that point yet, but I think the court has to ask itself within those 5 seconds, what would a reasonable person in Ms. Semensi's shoes have done differently? And when you ask what a reasonable person in Ms. Semensi's shoes would have done differently, you have to take into account the issues of cognitive ability. You have to take in the issues of stature, things of that sort that were shown in those studies that I cited. And if you do that, I don't see how the Commonwealth's theory that within that 5 seconds, Ms. Semensi should have been able to correct presented an unreasonable risk, because all of the evidence shows prior to that bump at the cement where the grass is, she was proceeding in a cautious way, backing up. Probably
Well, is
more
that a
cautious
question
than
for
most
the
people.
jury, though? I mean, wasn't there sufficient evidence to permit the jury to find beyond reasonable doubt that she could have moved her foot from the accelerator to the brake before hitting the victim?
Operating under the premise that we are talking about pedal misapplication and not spontaneous acceleration, which seems to be common with Mercedes and with those codes that were testified to in trial does raise an issue, although again, it wasn't vetted out by the attorney in any way, shape, or form. I would have to disagree with you. I think a reasonable person within that 5 seconds would have done just what Miss Semensi had done. She's in a panic mode. Her neurological senses are in a tunnel vision sort of state of mind. She's thinking her foot is on the brake, and what is the natural thing to do? To apply more pressure, which those studies show is what happens in spontaneous acceleration, because it isn't putting your foot on the brake is an involuntary.
And the jury couldn't find that 5 seconds isn't sufficient time for a reasonable person to realize, oh, if I'm pressing more and more and the problem's getting worse and worse, maybe I'm pressing on the wrong pedal. I better switch pedals.
I would suggest to the court, with her testimony that she was screaming for help, that the vehicle was going backwards, that she had no control of the vehicle, 5 seconds would not be sufficient.
But does the jury have to believe her testimony that she had no control of the vehicle?
No, they don't have to believe her testimony, but I would suggest to the court that they'd have to point to something else. And I don't think that the Commonwealth raised anything else. There was an exorbitant amount of testimony about what was not wrong with the vehicle.
Why isn't it negligent? Why isn't it negligent to hit the gas when you want to slow down in the first place?
Because it's a blind action. And as you get older, your cognitive abilities start to diminish.
Okay, but why doesn't that, oh, I'm sorry, go ahead, Judge.
Why isn't it negligent to take blind actions when you're driving a car in a parking lot?
We take blind actions every day, every one of them. And blind action is when, Justice, when you get in the car in the morning and you put the car in reverse and automatically put your foot on the gas pedal to back out of a garage.
I do not do that. That sounds really, really negligent.
Without looking at the gas pedal. You don't look at the gas pedal when you put your foot on it. It's a blind action.
But I'm just concerned about the scope of what you're suggesting here. Do you have a case that says, and of course we have no medical examination of the defendant to know any details about it, but it seems to me that there can be people who are unable to take due care. And the answer isn't, so we let them do whatever they want and say, as long as they do their best, it's okay. I think we say, you shouldn't be doing X. You are unable to take due care. And I would have thought that in a situation like this, if she is unable to hit the right pedal and unable to correct for that within, I've never been in a car that backed up over a curb, up a hill, across a road, killing someone and hitting a building. If she's unable to correct in that time, then she's unable to take due care and she shouldn't be driving. I mean, it's a sad situation for many older people, but I don't think you're suggesting that we lower the standard in order to let her without responsibility, let her drive in an unsafe manner. And I don't understand. Do you have a case that suggests that's what we do when we run into people who are inherently incapable of taking due care?
Well, first, let me point out that there's no evidence that Miss Semensi is in the state that you're suggesting. Knowing her personally,
I don't mean that she's. I'm just saying maybe she can't. Maybe if she's in this North Carolina study type of situation, that people with that risk maybe shouldn't drive.
But that is a legislative decision. That is not a judicial decision. We would be, if we carry that to its logical conclusion, then we would have AARP up up at the legislature saying, no, these
Well,
people
maybe
can
they
drive.
need to, right now, the legislature has said if you drive negligently, it's not okay. That's legislation.
And I would suggest to the court that negligence in and of itself has evolved in Massachusetts to be something more than an accident, and that this is just an unfortunate, tragic accident. There were no plus factors with reference to Miss Semensi. She wasn't speeding. She wasn't jumping a curve. She wasn't backing into the parking lot fast. Any of these plus factors that the case law has seemed to evolve into. With reference to your question about case law, this is a case of first impressions in the United States. And I went as far as having the librarian at UMass Dartmouth, research librarian, do a 50-state search of pedal misapplication where an individual has been charged with the death. And again, this is a case of first impressions. There is not one. The standard is an unreasonable risk. So the unreasonable risk would be the driving in and of itself, the backing up. In and of itself, I would suggest to the court that one incident of either a targeting, let's operate under the premise of a targeting error, would not in and of itself create an unreasonable risk. And I say the targeting error because my gut tells me that this is a case that's going to be a new trial motion and that this is a spontaneous acceleration case due to those codes.
Okay, your time has expired.
Thank you.
Are there any other, seeing no other questions? We understand your argument very well. It's a very interesting and terribly unfortunate case. We will hear now from Attorney Middleton.
Begin?
Yes, can you?
Yes, I can.
Oh, we need, the clock will begin,
Yes.
I gather, when you begin, I think.
Okay.
Hold on, let's see if that. There we
Let's
go.
see when. Good morning, Bridget Norton Middleton for the Commonwealth. The defendant raises 3 issues on appeal. The one that we've been speaking about the most obviously is efficiency of the evidence argument. Here, the Commonwealth presented sufficient evidence for the jury to find that the defendant operated her motor vehicle negligently. And I think, as Justice Sachs pointed out, this is a question for the jury. The jury listened to the Commonwealth's evidence. They applied the standard, the law as the judge gives them, and they found that this defendant acted negligently. Some of the evidence that the Commonwealth presented, and there was a lot of evidence. There was videotape evidence. There were 4 civilian witnesses. There were a number of exhibits. And there was Trooper George, who gave very, very lengthy testimony. And what Trooper George found, and he was a Commonwealth's reconstructionist. And in addition to being a reconstructionist, he's also a master mechanic. And he really gave great detail about examining this car. And part of examining the car was ruling out the other reasons why this may have happened and whether it was this defendant's actions that caused this accident. And I would say, first off, in terms of negligence, the second that she puts her foot on the gas instead of, it's not just a matter of not stopping the car once it's going backwards. The car is going backwards because as she's backing into the spot, the first thing what she does is she's tapping, is that she hits the gas instead of the brake. And that's negligent behavior. And the jury would be permitted to find that that was negligent behavior. The negligent behavior continues for quite some time, short in time, granted, but 192 feet. As we talked about, up a hill, cross a road, through bushes, striking the victim as he walked on West Elm Street in downtown Brockton, and then dragging him an additional 53 feet. The only reason why the car stopped is that it crashed into a building on West Elm Street. So some of the evidence that the Commonwealth, and I will, I'm sure the court is familiar with the record, but just to point out some of it, and I would say, before I get into the evidence, that the jury was warranted in finding that a reasonably prudent person would have hit the brake. We expect that. Regardless of your age, we expect that you hit the brake. The trooper looked at the car. The defendant was wearing a seatbelt. The safety features in the car were operating correctly. The airbags, because there was some testimony and suggestion during trial that maybe she had hit her head and was injured and couldn't have done this. The Reconstructionists confirmed prior to getting to the scene that there were no mechanical recalls for the vehicle, that it had a valid inspection sticker, that it hadn't been in any accidents. And then he looks at the car itself. He tests the brake and the gas pedal at the scene. They work. He looks at the car at the scene. He's able to start the car at the scene. He brings the car back to the barracks and tests it, puts it up on the lift, looks underneath it, he rules out any mechanical problems with this car. Then he test drives the vehicle. Under every circumstance, a Trooper George test drove the vehicle. Everything worked. The brakes worked, the gas worked. Even when he applied pressure to both the brake and the gas at the same time, the Mercedes has a lot of safety features that will override the error of the person driving it. And when he pressed on both of them, instead of the car accelerating, the Mercedes would slow itself down. He put it in reverse. He was only able to get it to rev up to, I think he said 20 miles per hour in reverse. So there's a lot of safety features that the Mercedes has that will override the error of the driver, and they all worked when he tried to use them. So he found that there was nothing mechanically wrong with the car. And then he used a code reader, which is something he explained at trial that is used very commonly when you're going to get an inspection sticker. So basically it's a machine that will talk to the computer of your car. And there are two kinds of codes that are stored in a car. One is a stored error code, and that's not for the driver, that's for a mechanic. And then there are active error codes. Those are for the driver. So if something's going wrong with your car, you'll get the lights, saying, you need your oil done, or there's something wrong with the steering, what have you. When he did the error codes for the Mercedes, there were only stored error codes. There were no active ones, so nothing indicating something actively wrong. And he explained that if there is an active error code, what happens is the Mercedes almost goes into a sleep mode. It would, I'm trying to think of the word that he used, but a sleep mode where you would just really have enough to get off the highway. So there were lots of features that are there for safety, and they all worked. There was some testimony about the manual for the Mercedes, whether it was warning you that if you put the car in, shifted it into gear while you had the foot on the gas pedal, that the car could jump. And the jury had that page, they looked at that page, but Trooper George testified that he couldn't even make that happen, that the safety features of the car overrode and the SUV actually decelerated if he tried to do that. He couldn't even get that to work. So here, Trooper George opined that the SUV did not malfunction.
Wait, I'm sorry, I think Justice Ditkoff has a question.
Sure.
Yeah, Counselor, you've mentioned some of the exhibits which
Yes.
we have in our appendices. Do you think we need any of these exhibits to decide these issues?
I don't. I'd be happy to send them. The two videos, one is quite from a distance. They show the car rolling backwards. The photographs, lay out the area, but I think that, the recitation of the facts is sufficient for the court to find that. But if the court would like those, I'd be happy to send the videos for the court to see.
I was just wondering if you thought there was some exhibit that's, that the case winner that we should be looking at.
I think that Trooper George's testimony is the case winner. I don't think there's one particular exhibit. I think that his testimony was detailed, it was comprehensive, it was credible, and I think the jury found that. And I think they were entitled to credit his testimony. And once crediting his testimony, there's more than sufficient evidence to find that the defendant operated her motor vehicle negligently. The defendant raises some other issues. If the court has questions on them, I'd be happy to address them. But if not, I'd be happy to rest on my brief for the other two issues.
You have a case, the implication of your brother's argument to some degree is this person did the very best she could, and that makes this an accident, not negligence. That is, if she takes the best care she can, that has to be due care. Do you have a case that squarely says it doesn't matter if the individual simply can't adhere to the standard? The standard is the standard, and that doesn't excuse.
Well, I come at that a couple of different ways. I think that I cited a case in my brief talking about this is not a specific intent crime, so the accident defense is not available for motor vehicle homicide. I believe I have a footnote in my brief on that. But the standard is the standard, and the purpose for the legislature is the protection of the public, and we can't have a different standard because you're older or not able to do the things that you used to do, or for some other reason. I mean, it's for the protection of the public, and it's a reasonably prudent person, and they have a duty of care to people on the road, to other drivers, to pedestrians. And it's a question for the jury. In the facts of this case, did the defendant meet that duty of care, or is there a negligent operation here? I think in these circumstances, the jury's more than warranted in finding that. There's no other questions. Thank you very much, and I'll rest on my brief.
Thank you both very much. Very helpful arguments. Very unfortunate case, of course, as I said before. It is submitted. Our next case is number 20-967. Thomas Zerfus and another versus Reading Memorial High School Band Parents Organization and others. The rules for argument when we hold it by teleconference, which we are doing today in light of the ongoing pandemic, are the same as the rules in our courtroom, which is to say 15 minutes per side with no rebuttal. When parties are dividing their time, as is happening in this case, they have to let us know in advance. And my understanding is that we will hear from appellees. Counsel for the Mahonies will have 5 minutes. Counsel for the other, I guess I'll call them individual BPO defendants will have 2.5 minutes, and then counsel for the town will have 7.5 minutes. Is that everyone's understanding?
Yes, Your Honor. Yes.
Excellent. So with that, we will hear first from you, Counsel DeMora.
Good morning, Your Honors. My name is Ken DeMora, and I represent Thomas and Lucretia Zerfus. I want to also mention my colleague, Melanie McCauley, who helped on the brief on this matter for us. We're here today to appeal the decision of Judge Saroof in the Superior Court on a motion for summary judgment. This case has been colloquially referred to as the golf cart case, but it's really not a case about a golf cart. It's a case about a truck. In this case, the town of Reading school system had a band and color guard program.
Yep. Mr. DeMora, I think we've got the facts pretty well. I wanted to cut right to the question of your claims against the Mahonies and Mr. Fallon. Are your claims based solely on their own negligent or grossly negligent actions, or do you seek to hold them liable for the negligent or grossly negligent actions of other officers or members or volunteers for the BPO?
Your Honor, I believe we are seeking to hold them liable as officers and officers of the BPO. And to the extent that we need to prove the conduct was reckless or wanton or a little more than negligence in order to get over the charitable immunity and get over any of these other immunities, that's our theory.
Well, I don't understand the phrase liable as officers of the BPO. Does that mean you're only going after them for the assets that belong to the BPO? My question is, whose negligence do you contend that you have to prove in order to recover? Is it sufficient to, do you depend on proving that someone else besides the Mahonies and Mr. Fallon were negligent, or is your theory that only they were negligent?
Only they were negligent here, Your Honor. The other individual members of the band parents were no longer parties to the case and were dismissed on summary judgment, were added because the band parents organization is an unincorporated association, and we needed to have under Rule 23 representatives who could defend the claim. So it is the direct negligence of the Mahonies here and what they did as officers of the BPO and Mr. Fallon.
And Mr. Fallon and nobody else.
Right, that is correct.
Okay, all right. So what did they do? You've cited the Dos Santos case, and you've suggested in your brief that they actively facilitated use of the Planck method by failing to implement a safe alternative. And it seems to me that there's a contradiction within that sentence. You say they were active by failing to do something. What should they have done, do you contend, that would have prevented this accident? Was it a duty to warn? Was it something else?
No, it was not a duty to warn, Your Honor. Here, the testimony of both the Mahoneys and Mr. Fallon, and the record shows that prior to this incident, prior to this accident, they, as officers of the BPO,
There was a discussion at the meeting. So what should they have done?
They should have stopped providing volunteers to the school, which they said at the deposition they had the ability and power to do. And they should have said to the school, until we're happy to volunteer and we're happy to continue to provide other support to the school and the band parent organization, but we will not allow our volunteers to load and unload the golf carts.
And so you're saying that they had a duty to Mr. Zerfus to stop providing him to the school?
You're right, Your Honor. They had a duty to make sure that the school, either the school provided its own employees to load and unload the carts, which again, Mr. Bunton was at was at these meetings, and he is the town employee, the director of the band program, to direct them that, listen, you either need to get a different truck that provides a safer way of getting these golf carts to and from these events, or we're not going to provide volunteers. Again, the way the system worked was there was a phone tree. There was a
why do they have a duty to stop providing Mr. Zerfus as a volunteer that is any greater than Mr. Zerfus's own duty to stop providing himself as a volunteer?
Well, I think in a couple of different ways. First of all, they assumed that duty when they became part of the booster organization program in the town of Reading and involved themselves as the group for the band parents that would assist and provide volunteers for the band parent program. The second is because the way that volunteers found out when they would be needed and where they would be needed was through the channel of communication provided by the band parent organization on their website.
Yeah,
and
I'm not questioning that they could have stopped. I'm asking you, why do they have a duty to stop providing volunteers that is greater than the volunteers' own duty, particularly where the volunteers are perhaps more aware of the hazards presented by the plank method than are the Mahoneys or Mr. Fallon?
In this case, Your Honor, I don't think first, I think that's a factual issue. Who was more aware of the risk or who wasn't, which should be reserved and left to the jury. And in this case, because this was decided on summary judgment, any doubts on that ought to be
well,
on our favor.
It might ordinarily be a factual issue, but Mr. Zerfus in his deposition said when he was asked which was the safest method, he said once he saw the ramp method, he thought that was much better, clearly better than the plank method. And he also acknowledged in his deposition that the ramps were available in the band room for use on the night of the accident.
I don't recall that Mr. Zerfus testified. I believe it was one of the other witnesses who testified to that. However, the fact is that there were ramps available for the job that were not being used. Instead, the planks had been brought to the location where the event was being held in order to load and unload the trucks. And they were the planks that were on the truck.
Were the ramps safe?
I don't know. There is some question about whether the ramps were any safer. In fact, I believe that if you look at the minutes of the meeting that was the subject here, October 6th, I think there's some question about whether that was a safer method to use the ramps.
I don't understand how you can say that, Mr. Demora. Mr. Zerfus testified at his deposition. It's Record Appendix 1, page 117 at the bottom. Of the three methods that you described, which one did you think was the safest method? And Mr. Zerfus answers, well, when I saw the method of the ramp, that's when I said, that's definitely a lot better. definitely seemed like an improvement over what we had done. So I would say, hey, this is much better. That would have been my answer. So is there a dispute of fact over whether the ramps were safer than the method that was used?
No, Your Honor, there really isn't. But the fact is, in this case, they were not available for Mr. Zerfus at that time.
Well,
The truck
Mr.
arrived-
Zerfus testifies in his deposition, record appendix, page 114. Question, so in October 2014, were the ramps still available to be used? Answer, they were available. Question, where were they kept? Answer, in the band room.
Well, I guess they were available
But
in the bedroom.
are you saying that that these ramps, how would I put this? Is there anything that raises a question about the safety of the ramps?
I believe there is. I think that the minutes to the meeting where Mr. Fallon says there's a concern about these ramps and needing to get a hitch to pull them and the like. And I just
Well, getting a hitch to pull them might mean that they're not usable. Is that right?
It may very well be. We didn't develop that record with the deponents.
But if we're trying to figure out whether the town is an original cause of this, all the town did was rent rider trucks with a lift gate, right?
That's right.
The town did.
Yeah, that's right.
Now, if those could have been safely used, for example, by using the ramps, then the town isn't an original cause of the accident, except to the extent they said, don't use the ramps, only use the plank method. But if the ramps aren't safe, if there's no safe way to do it with the trucks, then renting the wrong trucks might be an original cause.
Your Honor, I would disagree with you about this. I think that the fact that they rented those trucks when they knew that there were safety concerns about how they were being used to load and unload the golf carts creates.
I'm sorry, the town, when they rented the trucks, I gather, didn't know anything. They just rented some trucks, right? How could you know the trucks are unsafe before you rented them?
They knew that the trucks were unsafe for the purpose of unloading and loading these golf carts because—
Unless the ramps made it safe.
You're
right.
But Your Honor, 5 days before this incident, Mr. Bunton, the town employee, is sitting in a meeting with the executive board of the band parents, and they tell him the trucks are not safe to use to unload the golf carts.
Well, that's not what the minutes show. They're worried about the loading and unloading of the golf carts on the truck, and they discuss other ways to transport the carts, but there's no one saying the ramp method is unsafe. At least not in the minutes.
But I believe it put that in context. The testimony of the Mahonies and others was that's what they were talking about, was the way the plank method of going up and down using the planks as a way to load and unload the trucks.
When was the rider truck rented?
That morning, the morning of the day that Mr. Zerfus was injured. So 5 days.
How did that work exactly? I gather the town has some kind of account or something, or how do you know how the town rented it that morning, or how does it work?
Based on the record, the rental contract is an exhibit that's in the joint appendix, and I believe somebody from the town's business office calls Ryder Truck and says, we need a truck for the band. It's going to be picked up this day and dropped back off on this day. We need a lift truck, and then it's rented that way. So
was the call made before or after this October 6th meeting?
The only document we have on that, Your Honor, is the actual rental agreement, which has the date of October 11th on it.
I signed that. Who signed that on behalf of the renter?
On behalf of the renter, the person who picked it up, which was one of the band parent organizers.
So a BPO member, not a school official, is the one who picked it up. We don't know when the school official took the action of telling Ryder, we need one of your trucks.
I do not know that information, Your Honor.
Can I ask you this? Your time is short, but I'll give you time to answer if it takes longer than this. I am still confused about this question about the capacity in which you have sued the Mahoneys and Fallon. My understanding from reading the complaint was that they were adequate representatives of BPO, which I would have thought would mean suing them is a way of suing an unincorporated organization so that you can get money from the unincorporated organization, which I gather has some money.
It has, or an insurance policy.
Or whatever it has. I did not read the complaint. I found it at best ambiguous, put it that way, about whether you also meant these individuals did something aside from what BPO as an organization did that was negligent. And I know we're talking about it now in the briefing, and I haven't looked deeply enough at how this was litigated below, but I'm trying to understand, did you separately or in some way say it's not just because they're representatives and we want money from BPO, but they themselves acted grossly negligently, and we think they themselves are liable for that?
Your Honor, I believe the complaint does identify them, not just as adequate representatives, but identifies them in their capacity as officers of the BPO and alleges that their conduct was negligent and reckless.
And the gross negligence or reckless, I suppose, is above gross negligence that you allege on their part is not their actions as board members or whatever they are in failing to vote to do something on October 6th. It is that on the day in question, as the co-presidents of the organization and as the officer in charge of transportation, they failed to stop this from happening.
Correct, Your Honor.
So it is not their inaction as board members
Correct.
getting the organization to do something at that meeting. It is
correct.
Their conduct, their supervisory roles on the day in question.
Yes, they had notice of the risks and the harms and the ways to take care of this problem, and they didn't do anything about it. And that's, in our view, a fact question that a jury should have to decide. I see my time is up. I would request that the court reverse the decision of the lower court. Thank you.
I do have.
We have a question. Go ahead, you can answer.
So I noticed that when your client was asked whether there were any safety concerns to the ramp method, he didn't identify any. And you said that in the minutes, I'll find evidence that the ramp method was unsafe. Is there any other place I'm going to find evidence that the ramp method was unsafe?
Unfortunately, Your Honor, at this moment, I can't think of any, but if I recall correctly, there was some testimony that the problem with the ramps was that it was difficult to control the speed going down and there was a sag issue, but I can't remember where in the record that is. I'm happy to submit later references to the record if the court would like.
All right. I'm sure we can find it. Thank you.
We can find it. Thank you very much. Your time has expired. Thank you for your argument. We will hear next from Attorney Lyon.
Thank you, Your Honor. Gregory Lyon appearing for the appellees Brian and Carol Mahoney. Your Honors, today we face the threshold question of duty as applied to the BPO defendants, both as an organization and as individuals. As was alluded to in the appellant's argument, it was unclear as to in what capacity the Mahoneys had been sued.
Well, do you acknowledge that had the Mahoneys chosen to send out an email to all volunteers, just hypothetically, sometime before the date of the accident, saying complaints or issues have been raised about the safety of the loading the golf carts, for the time being, please don't use the plank method, use the ramp method, or for the time being, unfortunately, we just can't transport these golf carts using this lift truck. We need to find a safer method. Would that have been in their capability? And could a jury have found that that would have prevented this accident?
No, Your Honor, I don't believe that they had the capacity. As board members, they were required to act collectively as a board.
No, I think Justice Sachs's question follows my colloquy with Attorney Demora. As co-presidents of the organization, could they not have said, don't use the planks?
No, I don't believe that they had that authority.
Why not? They're the
Because
co-presidents of the organization.
they're constrained by the articles, which.
But I don't recall anyone saying, was there ever a board vote, use the planks, don't use the ramps? I mean, so what makes you think they couldn't have said, don't do it?
Well, because they're constrained to act collectively. They had no individual power to over Mr. Zerfus or any other.
Okay, so perhaps the board, executive board, could have voted at that meeting to send out such an email. The Mahoney's, as president and co-president, didn't make that proposal to the board. Could that be found to be negligent?
No, because they didn't have a duty to do that. Because what the issue here is who's in control of this operation. The BPO never exercised any control over the transportation of the golf carts. The only thing that they ever did was solicit volunteers to go help out. They didn't.
Do you represent the organization, qua organization as well, Attorney Lyon?
No, I do not.
Is there counsel for the organization, qua organization?
Yes, Your Honor.
Okay.
So,
all right, so let me ask you this. The band organization has a room somewhere, right? That has all the band stuff in it.
There was a place at the school where various equipment.
Is it padlocked?
I do believe the record reflects that it was locked and under.
Who has the key?
The town.
So what happens on the day in question?
With respect to getting the equipment out of it,
yeah.
I believe that Mr. Bunton, the band director, had the key and would open it for the volunteers to go in and access whatever they need to access.
I mean, it's a funny organization where the presidents have no authority. I've never heard of one.
Well, they have certain authority to do certain things. They could call a meeting and call for a vote. I mean, it's governed by the Robert's Rules of Procedure. But the question really for the court is whether or not they had a duty to do that.
So this Dos Santos case has been mentioned where, and it's an analogy, obviously, to the landowner context, but where there's an open and obvious danger. Sometimes the landowner may have a duty to warn, but in other instances where the landlord is somehow, or the owner is somehow actively facilitating bringing persons into contact with the dangerous situation, a duty to warn is not enough, that the landowner may have a duty to remedy. So by analogy, why wouldn't that apply here? That the Mahoney's had some duty to prevent volunteers from using this method that had at least been questioned and suggested was dangerous.
Because the Mahoney's and nor did the BPO have any control over of the method being employed. It's different from the landowner type cases where someone owns the property where the dangerous condition exists.
And you think that the email that that Mr. Mahoney, I believe, forwarded to the band parents organization members, or at least the e-board back in November of 2014, doesn't indicate that it's within the power of the officers or co-presidents to take some action like that. I understand he was relaying a request from the town, but clearly it was he who did it.
Correct, Your Honor. He had no power to do that without a vote of the board and was simply relaying the town message to not transport the carts in the same way that they had been.
Why isn't his power as liaison to the school give him a duty to communicate with the school about this dangerous way in which the equipment's being transported?
It does allow, for them to communicate directly with the school. But again, it doesn't create a duty for them to prevent the way the carts were being loaded and unloaded. I see my time.
Your time has expired. If there are no further questions, we will hear next from Attorney Murphy.
Good afternoon, Your Honor. Dan Murphy, and I represent Pat Fallon, and to the extent and all of the collective individuals of the band parents organization who are named on this complaint, and to the extent that the band parent organization entity itself was a party to this case, which I do agree is unclear. I represent that as well.
How can you represent the band parents organization and one of the individuals, Fallon, if now your argument may be different from Attorney Lyons' argument. He says the individual officers can't do anything. It's a collective act of the organization, I guess, or of its board must be able to do something. And so it is the organization's failure here, not the individuals. You're saying it's nobody's?
Well, Your Honor, I do think that the plaintiff's theory of liability evolved from its pleading stage to when it was defending its motion for summary judgment, particularly when it comes to the allegations that Mr. Fallon had any kind of duty of care that was separate from the individuals named in the complaint who were members of the BPO at that time.
Well, this job does include transportation, right?
Well, part of the duties of the internal vice president were to ensure that volunteer members were available to help, and that help included transportation of the band equipment. And Mr. Fallon was not deposed. He did not give deposition testimony, as I think Attorney DeMuro referred to earlier. We have an affidavit where Mr. Fallon lays out what his duties were with respect to his role as internal vice president. And truly, it was no different than the common goal of the BPO members at that time, was to help the band, to help the color guard, to make sure that there were enough feet on the ground to get the equipment to the band and the color guard for any given event.
Okay, so let's talk about the BPO qua BPO. It doesn't have any obligation to make sure that it's operating safely? So I don't believe people who are responding to its call for volunteers don't get hurt?
I don't believe that there's any particular member of the BPO.
I'm asking about the whole organization, the organization as a whole, acting collectively, whatever that means.
Right. So, Your Honor, the only situation where I can think of is if there is a unknown danger to everybody else in the BPO and not to Mr. Zerfas at that time regarding the loading and the unloading. And I think that it's very clear from the record that this was an obvious danger, that Mr. Zerfas had more opportunity to appreciate than the other BPO members who were named in this action.
So you're saying there could have been a duty to warn, but no duty to remedy. And the duty to warn was excused because Mr. Zerfas knew about the danger. Is that what you're saying?
I don't believe that there was a duty to warn, but hypothetically, if say that there was an accident using the plank method that for an event that Mr. Zerfas was not a part of and he had no knowledge of at that time, and that accident tipped off the BPO to this being a dangerous activity, which I do not believe. I believe it was inherently an obvious dangerous activity. But in that case, where the rest of the BPO is just discovering that this may be a dangerous activity, and they know that Mr. Zerfas does not know that at that time, then maybe a duty to warn would be would apply there. But that is not close to the facts of this case.
Does the BPO have a bank account?
Yes, it does.
What does it do with the money?
I believe that it is well, it does not fund the BPO officers. I
No,
know
no,
that
but
they are
I'm
not.
just, I'm asking what do they do? What does the BPO do as BPO? So here's this bank account, and then they decide what? We need more banners, or we need, like, what do they?
Well, I think they do
actually
raise money for, I'm sorry, but I think they raise money for band and color guard events, things such as uniforms, travel, expenses, food for the band and for the color guard when they
Who
are,
decides what disbursement is appropriate?
that I'm not aware of.
You don't know whether they act through a vote of the board every time they write a check, or if someone can sign a check, and you don't
Well, I
know.
know that there's a treasurer of the organization,
Okay.
but I don't know whether or not they vote on every budget decision.
Do you know of any of the checks being signed by anyone? Like, is there any evidence anywhere in here of them doing anything with any of their money?
Not that I have 100% sure knowledge.
I'm just trying to figure out how this thing works, like how, like in real life, when people want, when someone has an idea, but this is going to go across lunch, we better buy lunch for the kids. Whether, like, do they act collectively? Does the board act as an individual who's an officer in charge of lunches, do it, and do they seek reimbursement? But we don't have this kind of detail, is that right?
I think that they work collectively with the band and the color guard and their any given needs at that time. I think that they were organized for the purpose of doing the best that they can to assist the band and the color guard. They consist mostly of parents. They're uncompensated volunteers.
Mm-hmm. All right, your time has expired, but there may be.
Thank you, Your Honor.
Wait, there may be further question.
I do. Could you tell me again why the BPO doesn't have a duty not to place its volunteers in a position of danger?
I think that when the danger is obvious, as it was in this case, there is no duty that any particular member of the BPO warn of this danger. And I know that the Dos Santos case was referenced and talked about.
Well, I get that's why you don't have to warn people of an obvious danger. It's obvious. But you think that it's not negligent to place your volunteers in a position of danger?
Well, I don't know how. I don't agree that they placed the volunteers in the position of danger in the first place. I think that the record shows that.
I get that, but if they did, is that negligent?
I'm not sure what instance of placing them in danger we'd be referring to. I don't agree that the BPO placed anybody in danger in this case. I think, again, in one of the cases that's distinguished in Dos Santos is a case where
you don't have to answer my question. That's fine.
Okay, your time has expired. Thank you very much, and we will hear now from Attorney Crotty.
Thank you, Your Honor. Jason Crotty on behalf of the town of Reading. I'm sure you have some questions for me, but if I could just start out with one brief comment about a question that Justice Rubin asked plaintiff's counsel. You had inquired briefly about the rental of the truck on the day of the incident, and plaintiff's counsel mentioned, about a potential phone call or things of that nature between the town and the rental truck company. I just want to be clear, none of that was speculation. There's none of that contained in the summary judgment record. There's none of that contained in the appellate record. The way that it worked was the town had an account with the rental truck company. So they were the ones who paid for the trucks, but they had no decision-making and no involvement in any way, shape, or form about which truck was rented or who was the individuals who were renting it. The individuals who volunteered for the band parent organization would go to the truck rental agency whenever they needed a truck to transport band and color guard equipment, and they would, sign for it. The town would eventually get the bills, but the town played no role in selecting, did you need one truck, two trucks, bigger truck, smaller truck? There was no involvement in the summary judgment record, in the appellate record of the town dictating any of that.
But I'm trying to figure this part out. My impression was that, and I don't know, maybe this is just an inference someone is drawing, or I'm incorrectly drawing or something. I thought that without doing something else, all that the band organization could get from Ryder were these liftgate trucks. Now, I don't know enough about the account or what the town's arrangement with Ryder was, but is that a reasonable inference that what you could get from Ryder if you were a band parent or part of BPO or the right person was a liftgate truck like this?
I understand where you're drawing the inference from, but I don't believe that it's necessarily accurate. So my understanding is, and I'm not familiar, Ryder was a party to this case at one point, but they were let out very early. They were never deposed. So what they had at their disposal for various vehicles that they could rent to the band parent organization or members of the public, I'm not sure about. I mean, having rented moving trucks and things of that when I was in college, I know they have bigger trucks, smaller trucks, pickup trucks.
Sure, but that's not, I mean, of course that's true. And it may be that there's no such thing as a truck with a lift gate as long as a golf cart, or it may, you know what I mean? I have no idea. The inference I drew from something in the record, maybe it was the minutes of that meeting, I don't remember, was that, or maybe it's just the course of proceeding, which is then they stop for a long time. Then eventually they begin renting trailers from somebody else. The inference I drew was that they couldn't get something safer than this truck. I don't know whether the truck was safe or not, but safer than this truck from Ryder under the agreement. Is that I'm not saying that's true, but is that an inference that I could draw from the record?
So again, I understand why you're drawing the inference, but I don't think it's supported by the summary judgment record. There was no expansion upon why the members of the band parent organization who did the renting of the vehicles chose this particular vehicle.
Let me try it this way. You said there's no evidence the town selected the trucks, but is there evidence in the summary judgment record, undisputed evidence, that it was the BPO members who selected the particular trucks?
The only evidence in the summary judgment record is that the town paid the bill for the rental of the truck, but the BPO volunteers were the one who physically walked into the Ryder truck rental agency and signed the paperwork, and presumably, and here I'm drawing an inference, but presumably told the people at Ryder, this is the type of truck we need for what we're trying to accomplish.
If there's no evidence as to who got to pick the trucks in the summary judgment record, doesn't that mean you don't get summary judgment? You haven't shown that the other side can't prevail.
No, because I think the who rented the trucks or who chose the trucks is an issue that sort of plays into this, but the basis for summary judgment was the statutory public duty rule, 10J under the Massachusetts Tort Claims Act. And here, what we argued and what the Superior Court judge, in my view, ruled correctly was that the original cause of this incident was the conduct of Mr. Zerfus and using this particular method to load and unload the trucks. I mean, the summary judgment record shows.
Doesn't that assume that the trucks that at least a jury could find that the town selected could be safely loaded somewhere? If they can't be loaded in any safe way, isn't it the town in selecting the trucks that has created the problem?
So there's no evidence that the town in the summary judgment record that the town selected the trucks. And I think that there's
no evidence that anyone else did. I mean, so if we don't know it either way, if you guys didn't develop that for the summary judgment record, how can there be summary judgment?
I guess I would disagree with that respectfully. I mean, if the BPO parents or the BPO volunteers are walking into the Ryder agency and communicating with the people at the Ryder agency who work there, they're the ones who are selecting the truck or the vehicle that they.
But we have to view the evidence in the light most favorable to the non-moving party. And we don't know. It's not an unreasonable inference that people who don't change this right, despite knowing of this risk. Talk about a trailer or whatever, and it's years before they finally get a trailer, and the town pays for it. I'm not saying it you may be completely right as an actual matter of fact. This is just summary judgment. I'm just saying, don't we have to draw the inference that the BPO couldn't get anything better than the truck from both the minutes of the meeting and the course of conduct, where it's more than a year later that they first get, and it's from a different place, this lower trailer thing.
Understood, Your Honor. And I guess the way I look at that is, if the people who were renting the trucks, from the town's perspective, they're not loading the trucks, they're not unloading the trucks, they're not participating at all in getting the equipment from point A to point B. So if the people who are making those choices are using a particular type of truck, they're using it safely and effectively for over a decade, right? Because there's no evidence in the summary judgment record that this plank method caused any problems or any safety risks. So from the town's perspective, if the people who are renting the trucks, the people who are doing the unloading and the loading aren't asking for an alternative method or to rent a vehicle from someplace else, there would be nothing that would sort of tip the town off that.
Just to make sure I understand you, you're now arguing that there's no evidence in the summary judgment record that the plank method is unsafe?
Not that I don't recall that. I mean, my memory of the summary judgment record is that that when and we deposed 3 or 4 of the other members who volunteered that night, and the only testimony we got with respect to that was when. And just I want to just be clear, the plank.
Sorry, what about the MIT mechanical engineer who worked for Teddy Peanut Butter, who said it was too freaking unsafe?
Yeah, so I'm sorry if I misspoke. I don't, the plank method and the ramp method. So the plank method was highly unsafe. The ramp method was what I think the rest of the volunteers agreed upon would not be problematic, and that's what they had been using.
And so your position is that the town didn't cause the volunteers to use the plank method instead of the ramp method, and therefore the town didn't originally cause the condition or situation?
Yes, Your Honor. The decision was left 100% up to the volunteers, and the summary judgment record reflects that. Mr. Zerfas's children had graduated at that point and were not even any longer a member of the band. He sort of came out of retirement that night and used this, I don't want to misstate it, plank method instead of the ramp method that they had been using for some reason of his own choosing, and that's what led to the accident.
All right, I think we understand your argument. If there are no further questions, somewhat complicated cases, I suppose we've all discovered here. Thank you very much to all of you, counsel. This has been a very helpful argument for us. It's an unfortunate case, as so many are before us, and it presents some complicated issues. So thank you.
All right, we are live and recording.
Good morning. Welcome to the Appeals Court. Our final argument for the day is number 20-1065, DC versus GF. This is a partially impounded case, so I will remind counsel not to use names and to follow any other restrictions in the impoundment order. I'm Justice Rubin. I should say I'm joined today by Justices Sachs and Ditkoff. We are here by video conference due to the ongoing pandemic, but the rules are the same here as in our courtroom. It's 15 minutes per side. There's no appearance or brief by the appellee, so we will hear from the appellant only. And with that, I turn it over to you, Attorney Barry.
Thank you. May it please the court, I'm Kate Barry from Greater Boston Legal Services on behalf of the defendant appellant GF. The trial court in this case issued a mutual 209A restraining order against Ms. F, despite explicitly finding that Ms. F was not a threat to Mr. C, physically or otherwise. At the time of the hearing, Ms. F was protected by a restraining order against Mr. C, and in fact, Mr. C was facing criminal charges for violating that order. Furthermore, during the hearing, Mr. C admitted to multiple acts of domestic violence against Ms. F. Nonetheless, the court issued a 209A against Ms. F based on stated concerns about tensions and co-parenting between the parties. The issuance of this restraining order contradicted two well-settled principles of 209A law. First, 209A requires that all restraining orders be based on abuse. Second, mutual restraining orders are subject to stringent substantive and procedural requirements, which were not satisfied in this case. As a result of these errors, I ask the court to vacate the restraining order against Ms. F.
Counsel, you're asking us to vacate, right? Not
Yes, Your
to,
Honor.
not to rule that it can't be raised, not to find insufficient. Is that correct?
Yes, Your Honor, I'm asking the court to vacate. I believe that's an appropriate remedy under either the failure to find abuse or the failure to issue written findings, given that this was a mutual restraining order. That was the remedy in Corrado v. Hendrick, where the court did not find abuse. It was also the remedy in Utaro and Somi v. Air, in which the trial court had failed to make written findings in a mutual restraining order.
And the affidavit in this case, was there an ex parte order issued and this was the full hearing, or the ex parte order was denied and then procedurally, just can you tell me where we were when this order issued?
Yes, this was the hearing after notice. An ex parte order had already issued based on the affidavit in the initial hearing. So this hearing was the defendant's first opportunity to rebut the evidence of abuse.
And this is 10 days or within 10 days of the ex parte order issuing, is that right?
Yeah, approximately 10 days after the ex parte order. And so the court was required to make a finding of abuse at this stage. 209A Section 3 requires that all restraining orders be based on abuse. In this case, abuse required a finding that the defendant had placed the plaintiff in imminent fear of serious physical harm. And this is because 209A exists to protect victims of domestic violence. Limiting 209A as such prevents 209A from being used against domestic violence survivors for purposes of harassing and abusive litigation. I would argue such as the litigation we see in this case. 209A is not a panacea for addressing all social ills, nor a means of circumventing other processes, as stated in Corrado v. Hendrick. In this case, it was clear that there was no finding of abuse and that there was no threat of abuse. The judge says, I'm not finding you a threat to him, physically or otherwise. He says the only basis on which this restraining order was granted was tensions and co-parenting. And this sentiment was repeated several times throughout the hearing. Custody concerns or tensions and co-parenting cannot form the sole basis of a restraining order. We know this in part from Miranda, where the court found it improper to base the duration of a restraining order solely on the desire to make the parties resolve their custody dispute. Likewise, in this case, it was improper to issue a restraining order solely to address those tensions in co-parenting. There's nothing in the case law, nothing in the statute that allows tensions in custody to replace a finding of abuse. And so suggesting the court was perhaps referring to IMLE v. Aslan, which recognizes that contentious custody litigation is one factor among many that a court may consider in deciding whether to extend a restraining order that previously issued based on a finding of abuse. However, IMLE does not establish that custody-related tensions alone can form the basis of a 209A. And the court did suggest that abuse need not be proven at this stage because it was not an initial hearing. Because I think perhaps because it had already been, the abuse issue had already been decided at the ex parte stage. This calls, the defendant has the right. This was the defendant's first opportunity to rebut the findings of abuse. Due process required that the plaintiff restate his case, restate the evidence supporting abuse, and that the defendant be given an opportunity to rebut that
evidence. Did the same judge issue the ex parte order?
No, it was different judges.
I see. Okay.
So for that reason, we asked that the 209A be vacated because it was not based on a finding of abuse. The court also did not follow the stringent requirements for issuance of a mutual 209A. As I stated, there are stringent substantive and procedural requirements for the issuance of such an order. They should only be issued in rare circumstances. And this is essential to protect victims of domestic violence from retaliatory restraining orders, which can have a chilling effect on survivors seeking the protection of our courts. And for that reason, Utaro v. Utaro and other case law imposes special requirements before a mutual restraining order can issue. The court had suggested that this wasn't a mutual restraining order because they issued out of different courts or different divisions of the BMC. It's well established by Somi v. Ayer in the 209A guidelines that restraining orders are mutual, even if issued consecutively by different courts. And because it was a mutual restraining order, 209A Section 3 requires specific written findings of fact that point to the factual basis for finding that each party is suffering from abuse by the other. By itself, the failure to issue such written findings, and as in this case, is a basis to vacate the 209A, as seen in Utaro and Somi v. Ayer. The mutual restraining orders must also contain sufficient detail to apprise law enforcement about how to enforce the restraining order. They must reference the other restraining order, which this one did not do. And they must provide clear instruction to law enforcement about how to determine who has violated the restraining order. If both are in the stay away distance, for example, how is law enforcement to know who is violating the order without such clear instruction? It's an easy situation for a potential abuser to manipulate and a very difficult situation for law enforcement to enforce. Finally, the court must engage in an inquiry about who is the primary aggressor, and the restraining order should only issue if both parties are truly suffering from abuse. All evidence here indicates that Mr. C was the primary aggressor. We know that another court had already found that he had abused Ms. F. The only acts of domestic violence testified to in the hearing were Mr. C's acts of domestic violence against Ms. F, which were testified to by both parties. Mr. C's primary focus in his testimony was on the custody and child support concerns that he had. The court thus failed to adequately consider, who was the primary aggressor. They stated it, the question was, is there tension between the parties? Is there strife between the parties? Not, did one party abuse the other? Is one party the primary aggressor? And do both parties truly need protection from abuse?
Were you the lawyer that Ms. F talked to before the hearing?
I was not.
Was it someone from your Greater Boston, or we don't know?
It was not from Greater Boston Legal Service. It was another agency. I did also raise a sufficiency of the evidence argument in my brief. I won't go into depth in that. I'll primarily rest on my brief for that. I'm saying that Mr. C never testifies to feeling fear of Ms. F in the hearing, even when directly asked by the judge. Nowhere in his affidavit.
Similar to my first question, if we reverse on the basis of the order and the mutual restraining order, are you satisfied? Or do you want us to reach the sufficiency as well?
I mean, primarily we would like the restraining order reversed, regardless of the grounds. I do think it's.
Do you think it's fair to say the judge found that the defendant was not a threat?
I think that's the plainest reading of his statement. I'm not finding that you're a threat physically or otherwise. And even if that's interpreted as.
Well, if it's interpreted to say, I'm not going to make a finding about that, then it might be one thing. And if it's interpreted to mean you're not, then there's nothing, right? We're done.
It's error either way. I mean, of course, it's error to grant the restraining order if he is finding affirmatively she is not a threat. And if he's making the decision either way, the court must make a determination about abuse. That's essential in all restraining orders. And I would argue even more essential given that this was a mutual restraining order.
I guess what I'm trying to figure out is, we could certainly issue an order that would reverse this, but in theory, make it possible for it to be relitigated. I know it's not going to happen because the plaintiff is long stopped being engaged in this process. Or we could write something that would say, well, it's reversed and you couldn't even redo it. And I wanted, one of those is a lot simpler than the other. So I'm trying to get a sense of whether you care which of those two things happens.
I think this should be the end of the litigation. The restraining order should be vacated here and now by this court. I think given that really all these concerns about mutual restraining orders are to prevent harassing and abusive litigation, the way to end the harassing and abusive litigation is not to remand it, and however, hypothetically, to subject the defendant to possibly more litigation of this below.
Let me also ask you about the collateral consequences here. It's not really before us, and I don't know if you have any expertise in this area. My sense is that it's impossible to get these things off of someone's record in some way, that the fact that this issued is, I don't know whether this has been fixed yet or not, but that it goes into this database and it just lies there forever, waiting to trip someone up who wants to be a doctor or a teacher or something. Is it of any assistance to you or to your client? Is there a difference between an outcome that leaves this open, even though it won't be litigated, and one that says there was no basis for this?
So if this court vacates the restraining order, it will be subject to the 209A Section 7, which directs the records of 209A restraining orders in that database to be destroyed. I think that would remain an open question if this is remanded, and the trial court would ultimately have to make that determination. So it would certainly be better for Ms. F to have the restraining order vacated by this court, which would reduce those collateral consequences. The existence of that restraining order on her record, it could show up if Mr. C tried again, that would be on the record. If for some reason there were ever criminal charges against Ms. F, again, that would appear in her record, and it would be the best thing for her to have that obviously removed from her record.
But you think it's different between if we say the basis was wrong and then he doesn't show up at the next hearing and it's never a notice one, versus saying there was no basis in the first place?
I think that the surest way of having it vacated is for it to be done here. I think the trial court, if that were to happen, I think it runs the risk of not being vacated if this court remanded it for further findings from the trial court, or remanded it to determine if remanded it below. So in sum, the law requires that restraining orders be based on abuse. This restraining order was granted based on tensions and co-parenting rather than abuse. And it was a mutual restraining order not supported by written findings, not sufficiently clear to apprise law enforcement as to how to enforce the order, and did not meet the stringent requirements for issuance of the restraining order. So for these reasons, I would ask the court to vacate the 209A against Ms. F. And otherwise, I rest on my brief.
Thank you very much. Excellent argument, excellent brief as well.
Thank you.
Appreciate your